In order to start and file for a divorce in Texas, you need to file what's called a petition for divorce. That's a pretty fancy way of saying court papers. It's the document you file with the court in the proper county that explains to the court, hey, I'd like to get divorced. So that's where you get things kicked off. You can do that with a lawyer, and that's my recommendation, that you find a Texas-based divorce and custody lawyer to file those papers for you. Or if you can't or won't do that for some reason, you can file pro se on your own. Texas has residency requirements that must be fulfilled before you can get a divorce finalized in a Texas court case. And those mean you have to have lived in Texas as a resident for 6 months before a court can grant your divorce. The difference between being a petitioner and a respondent in a Texas divorce case is pretty simple. In Texas, when you file for divorce, you're called the petitioner. And the person you file against is necessarily called the respondent. It really represents who filed first and then who had to respond. That's it. In Texas, there's a 60-day mandatory waiting period from the time you file for divorce until you can get your divorce finalized in the court. There's a cooling off element. They don't want you to file for divorce and then 3 days later be able to be finalized in divorce and have some second thoughts. So it requires about 60 days. There are a few situations where you can get an exception, but that rarely happens. And in fact, I've never had that happen in one of my cases.